Ladies and gentlemen, my name is Keith Raines. I'm a circuit court judge. I wanted to share some important information about the hearing you're about to attend. Nearly 80% of the people who come to court do not have a lawyer with them, so we're used to hearing cases without lawyers. A lawyer can't change the facts or the law, so we'll do our best to sort out what is happening in your case, whether or not you have a lawyer. If the respondent comes to court with a lawyer, the petitioner may first request a 1-week continuance to hire an attorney. The petitioner may choose simply to go forward today. The petitioner has to prove the case. The petitioner must show that there was a legal basis for issuing the restraining order, and that it is necessary to have the restraining order to be safe. The burden of proof is more likely than not. This court does not investigate cases. It only listens to the testimony brought before it, examines the exhibits before it, and makes the best decision it can based on that. The petitioner goes first with his or her testimony and the testimony of any of his or her witnesses. The respondent goes second with his or her presentation. Then the petitioner has a last opportunity to answer any new issues raised by the respondent. At the close of the testimony of a party or a witness, the other party has a right to ask questions. As with many things in life, there's a good and bad side to asking questions. The good side is that you have a right to ask about things that may not have been fully explored. The bad side is you may not like the answer or agree with it, and you don't get to argue with the person who answered your question, even if you believe that they are wrong. You will have the opportunity to present your side during your time to present evidence. Remember that questions end with a question mark, and a question is not your comment or statement. Some of the best questions start out with, "Isn't it true that?" So it's a good idea to have a pad of paper and pen to remind yourself to respond to things that you may not have anticipated. The court will lend you pen and paper if you let us know. If the petitioner has additional witnesses, the judge may ask that the testimony of those witnesses be reserved for rebuttal. In the event that either party has multiple witnesses, the judge may ask the party to summarize what the witness's testimony would concern to determine its helpfulness. If you have any documents or photographs that you want the court to consider, please have them marked with exhibit stickers and numbers. The petitioner gets numbers 1 through 99, and respondent gets numbers 101 through 199. The clerk will assist you with the stickers as soon as your hearing is ready, but let the clerk know. The other party will have the right to look at any exhibit that you offer before the judge even sees it. So you might as well share that while you're waiting after this presentation. There are some appropriate and some inappropriate objections to testimony of a witness. Typical good objections include hearsay, in which an out-of-court statement is being offered in court to prove the truth of what it says. A statement by a party is not hearsay, and there are some exceptions to the hearsay rule. Another good objection can be relevance, meaning that the evidence is not reasonably related to prove any part of the case. The bad objections typically are, "That's not true." Again, if you disagree with the statement of a witness or a party, be sure to note it down and talk about it on your turn. If you have any questions about the law or how it applies to your case, let the judge know. While the judge cannot give you legal advice or recommend a course of action, the judge will provide you with the court's best understanding of the law and how it applies to your case. If you have a child with the other party and there's been some provision made regarding custody or parenting time, the court will take a quick look at the issue, but not an in-depth review that would only happen in the family court if a custody case were filed. The law presumes that an abused person is entitled to custody, but that presumption can be overcome by other factors. Children have a right to a relationship with both parents. We'll create a parenting time order to assure that the child is safe and comfortable in seeing both parents, but also one that assures the non-custodian of a non-hostile atmosphere in which to exercise that parenting time. If supervised parenting time is proposed, please talk to your proposed supervisor, confirm availability and willingness. The state and the court do not have any resources to provide supervisors for parenting time. it's up to the parents to identify an appropriate resource. If the restraining order is continued in effect, the respondent will not be entitled to purchase, possess, or sell firearms or ammunition so long as the restraining order is in effect. That's federal law, and we can't do anything about that here. If the restraining order is continued in effect, it will be in effect for the balance of the year, starting from the date it was issued. If the restraining order is dismissed or vacated, the respondent should keep a copy of the dismissal in his or her possession at all time, in case the police make a mistake or the sheriff's records don't show the dismissal. We have a very large volume of cases, which requires us to move quickly through them. If there are other issues which need resolution, such as marriage issues, divorce, custody, parenting time, support, division of debt or assets, you need to file a separate court action. If you want a court to look more in depth into a custody or parenting time issue, you need to file a separate court action. I urge you to contact an attorney for advice. As helpful as our court staff wants to be in filling out forms, none of us can recommend a course of action for you or give you legal advice. Only a lawyer can do that. This is a lot of information. You may be nervous. To review simply, please don't interrupt a witness or party's testimony except to make a proper, that's a hearsay irrelevance, objection. Don't answer a question that is not asked of you. Do answer questions asked of you unless you have a proper legal objection. Take notes. Don't argue with a witness or a party over an answer. When the judge is ruling, it is too late for you to try to offer new evidence or to argue about your case. If the court orders a parenting plan that doesn't work for a child or a party, and you've not already talked about it, raise your hand so the judge will know that there may be something else that may be missing from the equation. Now, please join me now in turning off your cell phone. Let everybody that came with you know to turn off their cell phones too. Thank you very much for your attention.